property of married women under the common law. Under the common law, when woman marries, she and her husband becomes one person in law. The very being or legal existence of the woman is suspended during the marriage or incorporated and consolidated into that of the husband. It is under the husband's wings, protection and cover that she performs everything. It can be said that the wife lost her rights to her name, properties and heritage. If the wife is indebted before the marriage, the husband is bound afterwards to pay the debt. If the wife is injured in her person or her property, she can bring no action for redress without her husband's concurrence and in his name. She cannot be sued without making the husband a defendant. In trials of any tort, they are not allowed to give evidence for or against each other, principally because of the concept of union of person. However, in criminal prosecutions, the wife may be charged and punished separately for only civil union. The common law rule that makes a man and his wife one in the eyes of the law has been removed in England since 1962 with the passing of the Law Reform Husband and Wife Act 1962. In Malaysia, married women are governed by Married Women Act 1957. Section 3 of the Married Women Act states about the application of the Act to Muslims to be subject to Islamic law. The Act applies to all married women and their property, rights and obligations subject to the Islamic law and the customs of Malays. Regarding the rights and responsibilities of married women under Married Women Act, generally, a married woman is capable of acquiring, holding and disposing of any property liable in respect of any tort, contract or debt or obligations. She is also entitled to remedies as if she were a free soul or an unmarried woman. Section 2 of the Act defines married woman includes any woman married in accordance with the rites and ceremonies required by her religion. Manners or customs and property includes a thing in action. Now, let us see the capacity of married women. Section 4 of the Married Women Act states that a married woman shall be capable of acquiring, holding and disposing of any property, be capable of rendering herself and being rendered liable in respect of any tort, contract, debt or obligation, be capable of suing and being sued in her own name either in tort or in contract or otherwise, and shall be entitled to all remedies and redress for all purposes, be subjected to the law relating to bankruptcy and to the enforcement of judgments and orders in all respect as if she were a free soul. Section 4A of Married Women Act states the capacity of husband and wife to sue each other for personal injuries. It allows a husband or wife to sue each other in tort for damages in respect for injuries to his or her person in the like manner as any other two separate individuals. In the case of Farida vs. Muhammad Habibullah, the plaintiff sued the defendant for assault. The issue was whether the plaintiff could sue her husband when Section 9 Clause 2 of Married Women Ordinance back then prohibit a wife to sue her husband in tort. It was held that since the allegations of assault and battery constituting the tort were not related to the protection or security of property, the plaintiff was barred by Section 9 Clause 2 for suing the defendant. Thus, this case prompted the government to replace Section 9 Clause 2 with Section 4A. Section 5 of the Act mentions that if the property was that of a married woman or property held for her separate use in equity, that property belongs to her in all aspects as if she were a free soul or an unmarried woman and may be disposed accordingly. While Section 6 abolishes husband's liability of his wife's tort and anti-nuptial contracts, debts and obligations before or after marriage. Regarding the protection of their property, Section 9 Clause 3 depicts that any criminal charge or in any proceeding relating to the property of a married woman it is sufficient to allege that sued property is hers. Section 9, Clause 4 provides situations of criminal proceeding between husband and wife. That is, firstly, where husband and wife are living together, there is no criminal proceedings may be taken. Secondly, where husband and wife are living apart, but the act complained of concerning property occurred when they were living together, there will be no criminal proceedings can be taken as well. And thirdly, where husband and wife are visiting or about to leave, the act complained of concerning property occurred when they were living together. In this situation, criminal proceedings may be taken, and it should be politely noted that if husband and wife living separately while concerning the property, criminal proceedings may be taken. Next, under Section 10 of the Married Women Act, a woman after her marriage will continue to be liable for all debts contracted and all contracts entered into or wrong committed by her before the marriage. Section 11 provides that in instances of doubt between husband and wife pertaining to the title of possession of the property, either party may apply to any judge of the High Court or Sessions Court. Any dissatisfied party may appeal to the Court of Appeal. And finally, Section 12 states that the wife may sue or be sued if she is an executrix or a trustee either solely or jointly with any other person or persons.
Warahmatullahi wabarakatuh, and good afternoon. My name is Muhammad Farhan bin Muhammad Pauzi. Metro number is 281890. Today, I'll be explaining on the effect of marriage on the status of a person, other than what has been explained by my friend Subashini based on the Married Women Act. The first one is that the children born out of valid marriage are considered legitimate and they have the right to inherit their parents' property. This is based on Section 113, where the minimum month for a child to be considered as legitimate is 6 months. And based on the case of Wan Khairi bin Wan Azmi versus Nur Liliana binti Jauhari, the applicant was seeking the order of the court to declare the child, a baby boy delivered by the respondent on December 7, 2010, as the legitimate child of the parties according to Hukum Syara. The parties were married on June 9, 2010. The court held, among others, that the baby was born more than 6 months from the date of the marriage. They had already been staying together at the time of their marriage, and the husband had been able to consummate the marriage before the birth of their baby boy. Therefore, the child was ascribed to the father. Next is the mutual rights of inheritance between husband and wife are established. This is based on Surah An-Nisa, verse 11, 12, and 176, where it explains that an heir of a deceased include husband and wife of the deceased. Next is the prohibited relationship for purposes of marriage is created between the husband and wife. Based on Section 9 of the Islamic Family Law Act 1984, subsection 2, no man or woman, as the case may be, shall, on the ground of affinity, marry his mother-in-law or father-in-law and the descendants of his wife, how high soever, his stepmother or her stepfather being his father's wife or her mother's husband, his step-grandmother being the wife of his grandfather or the husband of her grandmother, whether on the side of the father or the mother, his daughter-in-law or her son-in-law, his stepdaughter or her stepson and her or his descendant, how low soever, from a wife or a husband with whom the marriage has been consummated. The fourth one is the cohabitation and sexual intercourse between the husband and the wife becomes lawful. This is based on Section 155 of the Administration of Islamic Law Enactment 1978. Any male Muslim who cohabits husband and wife with any female Muslim or non-Muslim without any valid solemnization of marriage in accordance with Hukum Syara, and not prohibited to marry by reason of consanguinity, affinity, and fosterage, is guilty of the offence of cohabitation. And also in section 23 of the Sharia Criminal Offences Act 1997, any man who performs sexual intercourse with a woman who is not his lawful wife shall be guilty of an offence and shall, on conviction, be liable to a fine. So, by reasons of these two sections, we can assume that when a man and a woman marry each other, their sexual intercourse and the cohabitation will become lawful. Also, based on Sahih Muslim Book 8, Hadith number 3302, Uqbah bin Amir reported Allah's Messenger as saying, the most worthy condition which must be fulfilled is that which makes sexual intercourse lawful. This hadith explains about the validity of sexual intercourse of a husband and a wife. And the last one is the husband gets the right to guide and prohibit the wife movement for valid reasons. Based on section 59 of the Islamic Family Law Act 1984, a wife will not be entitled to maintenance when she is nushuz, when she withholds her association with her husband, when she leaves her husband home against his will, or when she refuses to move with him to another home or place. So when wife did not obey the husband's command based on valid reasons, the wife will become nushuz and not entitled to a nafkah or maintenance. Thank you. I will pass the presentation to my friend.
So, moving on to the status of the property in regards to joint property of the marriage, which has been explained under Section 58 of IFLA 1984, the court may order division of asset acquired during marriage by joint effort during the talaq or order of divorce. However, the court in dividing the joint property must always consider the contribution made by each party in terms of money, labor and property, the contribution of the welfare of family, and also the need of the minor children if both husband and wife have any. For instance, we can see in Nolia binti Abdul Aziz against Muhammad Yusuf bin Abdul Rahman 2004. In this case, after the divorce, the plaintiff filed for her right as a wife where she claimed half of joint property, which property acquired by both parties during their marriage. The joint property consists of double-story terrace house valued at 216,000 ringgit Malaysia, a car which is a Proton Wira, and a motorcycle. The husband also claimed another car which is Kancil to be put as joint property. Then, while waiting for their divorce proceeding, the parties settled 3 out of the 4 assets in the dispute. Regardless, the issue in this case arose when the husband sold one of the joint properties, that is the said house, which is under his name. So, the court in their judgment acknowledged the plaintiff's indirect contribution to their marriage by taking care of the family, educating their children, serving the husband, and also her direct contribution in obtaining the asset, which is the house, by providing 6,200 in acquiring the house. Therefore, the court held that the wife is also entitled to 1/3 shares of the house, which is equal to 52,740 ringgit. So, in conclusion, we can see that the effect of marriage has rendered the plaintiff to have the share on the property, even though it is under her husband's name and her contribution in terms of fund is relatively small. Thank you.
So next, I'll be discussing about the other party of the effect of marriage on the property under Islamic Family Law Act 1984. As the previous presenter presented about the joint efforts of the property, I'll be presenting about the sole efforts of the property. Sole efforts. Sole efforts means that the property acquired during the marriage through the sole effort of one of the parties to the marriage with conditions stipulated by Hukum Syara. So, Section 58, Subsection 3 of the IFLA 1984 reads that the court shall have power when permitting the pronouncement of talaq or when making an order of divorce to order the division between the parties of any assets acquired during the marriage by sole effort of one party to the marriage or the sale of any such assets and the division between the parties of the proceeds of sale. In exercising the power conferred by subsection 3, the court shall have regard to the extent of the contribution made by the party who did not acquire the assets to the welfare of the family by looking after the home or caring for the family. Secondly, the needs of the minor children of the marriage, if any, and subject to those considerations, the court may divide the assets or the proceeds of sale in such proportions as the court thinks reasonable. But in case the party by whose efforts the assets were acquired shall receive a greater proportion. Next, for assets acquired by the sole property of one of the party to the marriage, the court may divide the assets in such proportions as the court thinks reasonable. However, this is also subject to certain factors, namely the extent of the contribution made by the other party, who did not acquire the assets to the welfare of the family by looking after the home or caring for the family. So, the provision which was stated in the previous slide is well explained in the case of Ida Khatijah binti Arshad versus A. Rahman bin Isa. The appellant of this case admitted that the property was sole effort property to the respondent since her direct contribution was absent and agreed that the greater proportion should be given to the respondent after considering her indirect contribution for taking care of the welfare of the house and their 6 children without the help of any servant for the past 19 years. So, the Sharia Appeal Court, in delivering its judgment, highlighted that direct contribution only occur in the category of property acquired with joint efforts in the form of contribution of money, property or work to obtain the asset. So from this discussion, it is very clear that there is no certainty in constructing the word joint effort. In some cases, the statutory provision has been interpreted strictly in the sense that there must be a direct financial contribution to the constitute of joint effort property, while in other cases the court seems to exercise its leniency in recognizing the indirect contribution of the wife, for example in taking care of the family, as works towards the acquiring of the asset and property then considered as jointly acquired. So that's all from me.
In conclusion, marriage does not generally affect the personal status of a Muslim woman. She retains her property and wages, and her earnings acquired or gained by her belongs to her. She is entitled to sue in her own name in respect of her property and in respect of contracts entered into by her. Thank you.